Well, good morning. I think we'll go ahead and get started. I'm Sarah Dunaway, and this is Jennifer Reedstrom Bishop, and we're both attorneys at the Great Plant Moody Law Firm. We actually live here in Minneapolis. We're right across the street, but we've come to this conference every year, so it's delightful to have you all come visit us in our hometown. What we're going to do this morning is talk about the key legal issues that we see when we're working with social enterprises, and the first question we always get is, we want to be, right now, we want to be a B Corp. How do we do that? And we'll talk through how we think about that question and the answers to that question, or the questions actually we come back at you with before we can answer that particular question. I'm going to leave the doors open, but if it feels like it's too noisy, maybe one of you in the back could shut them. But for now, people are still trickling in. So anyway, let's get started. So as I said, the first question we get is, we're a nonprofit and we're thinking about starting a social enterprise, and what should it be? Sometimes there's variations on this question. A couple years ago it was, we want to start an L3C, can you help us do that? And today it's, we want to start a B Corp or a Benefit Corp, and how can we do that? And really from our standpoint, the legal question about legal entity should be the last question. Because really the choice of entity should be driven by your business and what it is you're trying to do and how it relates to your mission, rather than starting with structure and building a business behind it. So we ask a bunch of other questions ahead of time. What's your mission? What is it this enterprise is going to do? How do they relate to each other? Are there other considerations? And that leads us to the question, then what should it be from a legal standpoint? And since I have a math background, I think of it in terms of a decision tree, which is the framework we're going to use for our discussion this morning. Our first question up front is it substantially related to your mission? And if yes or no, we kind of walk through the analysis of some other considerations, and that will drive the decision about which kind of entity it should be at the back end.
Can you explain
Yes.
substantially?
I will hold that question, and if
Okay.
I haven't answered it, you come back at me with it, okay? So first, I just want to spend a couple minutes laying some background just to make sure we're all on the same page. I suspect for many of you this will be review. But the first thing is terminology. When we talk about nonprofits, what is it that we actually mean? And I think for most of us, we're talking about a legal entity that has two primary characteristics. One is that it's a nonprofit corporation under state law. That's what governs kind of the articles and bylaws and those kinds of governance considerations. And that it's also a tax-exempt organization under federal tax law. And most of the organizations we work with in this field are 501c3 organizations. There's actually 26 different categories under 501c. You may have heard of 501c4s recently. It's a different category. But I think for purposes of today, when we talk about nonprofit, we're talking about nonprofit corporations that are tax-exempt under 501c3. The reason this is important is that, these are two different bodies of law. They both have their own sets of rules. They often are similar to each other, but not identical. So we have to think about both of them when we're thinking about legal entity structure and what you can and can't do in a nonprofit context. And the 501c3 piece, of course, is one of the most valuable parts of being a nonprofit, so it's precious and something we want to protect and hold dear. And it's important to remember that that's a federal tax law concept, and it's a privilege. You have to qualify to be a 501c3. You actually have to apply and have the IRS tell you that you are, in fact, a 501c3, which means you meet the IRS's definition of doing charitable activities, not just good things in the community, but a more narrow definition under the tax code and the IRS interpretation of it. And when you did that application process, whether it's today because you're a new organization or it was 35 years ago when your organization started, what you tell the IRS you're going to do is the basis of your tax-exempt status. And that's something that's unique to your organization. And when we talk about substantially related, it's related to what? That's what it's related to. So one question we often get is, well, these other people are doing this thing. We want to do just what they're doing. They might be able to do something differently than what you can because their basis for tax-exempt status is different, or vice versa. So it's important to remember that your organization is unique, and we need to take into account the unique characteristics of your organization when we're looking at these questions. So another question we get, maybe a little bit less so today than we did 10 years ago, is can we even do this? Is this legal? And I think many people have had the experience, if you work with maybe a pro bono lawyer, a volunteer lawyer on your board whose specialty is doing something other than working with nonprofits, or an accountant who likewise has a whole range of specialties, and this is just one little thing that they do. When they start hearing about running a business and charging people commercial rates and doing things that sound a lot like a commercial business, the answer frequently is, well, no, you can't do that. And the answer, that's not quite correct. There's much more nuance and detail to it, and as you've seen at this conference, there's lots of examples of people doing this, so clearly it can be done. But there's some really important rules that we take into account, and how you do it, of course, is important. So there's 4 main rules that we have to keep in mind when you're talking about a nonprofit. The first one is that substantially all the activities of a nonprofit have to be related to and in furtherance of the mission. It's not 100%, but it's got to be most. So that's one really important concept. The second is when it's interacting with the public, especially in a business context, engaging in commerce and selling trade or business, selling and buying goods and services, they have to be on fair market value transactions. You can't use the tax-exempt status of the organization to benefit a business or a private interest that doesn't pay fair market value for the benefit it's getting. That's different than if it's engaging in the conduct and serving its charitable class. So if you're a poverty relieving organization and you help provide meals for people who are suffering from hunger or homelessness, those are the people you're supposed to serve. You don't have to charge fair market value for that. Or if you're a school and you're educating students, you don't have to charge fair market value for that. But if you are selling a commercial service to a law firm to raise money to support your mission, that does have to be a fair market value transaction.
May I interrupt?
Yeah.
So if I'm a social enterprise and I'm receiving a benefit such as rent for free, does that classify as not receiving something that's fair market?
You can always give to charity.
Okay.
Okay?
But
It's the taking away that's the part that has to be fair market value. Thank you for helping me clarify that. Another key rule that we keep our eye on is the rule that there can't be too much private benefit and there can't be private inurement. And what this is looking at is insider deals and making sure that the organization itself is operated to benefit the public or the charitable, the charitable class that it's intended to benefit as opposed to insiders. And this can be an issue when we're looking at hybrid organizations, a closely affiliated nonprofit and for-profit company, for example, where the nonprofit becomes the exclusive customer of the for-profit. We want to think really carefully of, does that nonprofit really just exist to feed business to the for-profit? And even if it's on all fair market value terms, is it really just benefiting that one business and not benefiting the public in the way that a 501c3 is supposed to? So that's a question we think about carefully when we're structuring these. And then the final one is really important to remember, which is that the assets of a 501c3 organization are forever dedicated to charity. So there's no exit, there's no buyout, nobody owns equity in this. There's no, we've built this enterprise and then at the end we're going to cash out and I'm going to be able to retire. Those assets are forever dedicated to charity. It can sell a business, but then you got money in that 501c3 and that money then needs to be used for 501c3 purposes. So getting back to the question of structuring a social enterprise and our very first question, which is it substantially related to the mission? So let's talk about what we mean by that. So the reason we ask that question is that nonprofits are allowed to make a profit. So the term nonprofit is really misleading. The difference is that those profits are not distributed to any individuals or shareholders. They are retained in the organization and used to further its tax-exempt purpose. So no individual shareholder distributions or anything like that. Most of that profit is, if it's from activities that are related to the mission, even if it's selling goods and services, if they're related to the mission, it's tax-free. Corporation doesn't pay income tax on it. But if it's from an unrelated activity under the IRS rules, it's allowed, but it's taxable. And I'm going to talk a little bit more about this. So thinking about this relatedness is a really critical question in the social enterprise context because often you're looking at adding a business that's selling goods or services. You're going to use the money to support the mission, but the conduct of the activity itself has to be related to the mission. It's not just that you're using the money to support your mission, but the thing you're doing is advancing your mission in a really critical way. So some examples of selling goods and services. If you're selling artwork, may or may not be related depending on who you are. If you're a museum and whose charitable purposes are generally to educate the public about art. Selling reproductions of works of art in your collection advances that mission. You are getting more art into the public, more education about art, and more appreciation of art. That advances your mission. Likewise, if you're a program for people with disabilities, and some of the work that you do is helping artists with disabilities advance their own careers, but they need some assistance in doing that because of their disabilities, helping them sell their art might very well advance your mission. If you're an organization that doesn't have anything to do with advancing art, but you have this great product, or you have someone on staff who's a really good artist who's willing to donate their time and help you sell it, maybe not related to your mission. Selling hamburgers is another good example. If you operate a McDonald's franchise, there's really nothing about selling McDonald's hamburgers that's charitable. I can have a really hard time coming up with an example that would make it related. If, however, you are a workforce development program and your mission is about training people who are underemployed, who have had chronic barriers to employment, to learn the skills of being an employee and those soft skills of showing up to work on time, of carrying yourself with dignity, of interacting with the public. And the way that you do that is by operating a McDonald's franchise, and it's really structured in a way. Now, McDonald's is probably not a good example because they have all kinds of rules about what you can do in a franchise, but a hamburger joint, it's all staffed in a way that's really advancing that workforce training mission as opposed to the selling of hamburgers. But the fact that people are able to work in that business is advancing their training. That very well may be substantially related to your mission. Thinking about providing services, if you're a healthcare provider, the fact that you charge fair market value or commercially reasonable rates to do heart transplants advances your mission. But again, if you aren't in healthcare and you're selling services, not necessarily advancing your mission. And the biggest example of this is leveraging in-house capacity for things like kind of back office, so management, accounting, bookkeeping services, record-keeping services, often a social enterprise that organizations think of we have this fabulous capacity to do this. We want to help other nonprofits in the community by sharing the time and expertise of our CFO, for example. The fact providing financial services is not normally a charitable activity just on its own, and the fact that you're working with other nonprofits doesn't turn it into a charitable activity. There has to be something about the fact that you're providing that service that advances your mission. So just to give you an example, in Minnesota here we have an organization whose mission is to help low-income individuals become more financially sophisticated, and they do in fact provide those kinds of financial services to individuals and other organizations, but in doing that they're building capacity, and that's their mission. So for them to sell those services would be related, but for most nonprofits that's not likely to be a related activity. Fixing cars is another example. Not a lot of, if you're running a commercial machine shop, that's kind of a commercial activity. On the other hand, if you are a school that's training people on how to become mechanics, the fact that you fix cars and you charge people for that would be related to your mission. So a couple of myths that we get on relatedness. One is that we use all of our money to support our mission, and that is not good enough. You got to look at what it is you're actually doing. And the other myth that we run into is, but we're doing, all the clients are nonprofits. And my response to that is, if that were the case, my law practice would be a charitable activity, and I don't think any of us would dispute that that's not the case. So neither one of those are enough. You need to look at the conduct of the activity itself. And again, that's one that gets back to your unique organization and what your mission is, and the fact that my financial services company can sell financial services and have it be related doesn't mean if you're an animal welfare organization and you're selling financial services, it makes it related for you. So now looking at that piece, thinking about it a different way of the streams of money and where is it coming from into your organization and how does it get taxed. If it's from a related activity, even if it's charging prices rather than contributions, you're charging prices for goods or services that you're selling. If the activity is related to your mission, there's no limit on how much money you can make from a tax standpoint. And you have to use it to advance your mission, and it's free from income tax. If it's from an unrelated activity, you are allowed to do it, and you are allowed to have some unrelated income, but it will be taxed at commercial corporate rates, and it's called unrelated business taxable income. So the idea for it being subject to tax is that nonprofits shouldn't be able to unfairly compete with for-profit businesses just because they're tax exempt. One of the most early cases of this was a school, a boarding school for kids that opened and ran a macaroni manufacturing company. And it had nothing to do with education. They weren't using their kids to work in the school or anything that had anything to do with the education. It was purely an investment that supported the mission of the school through the generation of revenue. And you know, they were making and selling commercial macaroni and competing with all other pasta companies. And the policy argument is, if that's what you're doing, fine, but you need to play on a level playing field. The other piece is, this gets to the substantiality question, is that you can't have too much unrelated business income, because then you are no longer substantially furthering your mission, you're operating this unrelated business. There's not a magic number of when you have too much UBTI. The general rule of thumb is if you're under 10 to 15% of your total income is coming from an unrelated activity, it should be just fine. You start going above that number, that's when we look at maybe moving it into a separate entity, and we'll talk about how you would go about doing that.
What is UBTI?
Unrelated business taxable income. You also hear UBIT, U-B-I-T, which is unrelated business income tax, and that's talking about the tax you pay, and when it ends with the I, we're talking about the money coming in. Just to give you a moment of tax, when I was 23 and I said I wanted to go to law school to work with nonprofits, if I had any idea these are the things I would be talking about. I've never done it. I would be saying things like UBTI. The taxable income is, the definition is that it's income from a trade or business that's regularly carried on that's not related to your purposes. If you do a big plant sale once a year, it's not likely to be considered regularly carried on. But if you operate in kind of competition with garden centers and you sell seasonal plants consistent with the seasonal sales that are available, then that would be considered regularly carried on. The trade or business prong of this test, if we're talking about a social enterprise and you're selling goods or services, you're always going to meet that one. And then the unrelated related thing we've already talked about here. I would be remiss to not mention there are several examples to the unrelated business income tax, and I'm not going to go into them in detail, but this is the moment where people start to panic. So there's an exception for passive income. This is your classic investment income. If it's rents from real property, royalties on like intellectual property, or if you own a mining interest is considered a royalty, dividends, interest income, capital gains. So all those, most of what you would earn off of an endowment fund or an investment fund are typically not taxed as unrelated business income. There's a whole bunch of little detailed rules that you get in there that make it more complex than that, but as a general rule, passive income is not taxed. There's a big exception if it's from your own subsidiary. You kind of take yourself back out of the UBTI exception, which will be important in a little bit. And if you are providing substantial services in connection with generating this revenue, you also take yourself out of the exception. So if you own a building and you just lease it out to tenants and you don't do anything more than being a landlord, that would be rents from real property that's accepted. But if you are also in there providing substantial services and coaching and selling your CFO time and working with their employees to do leadership development, it takes the whole thing out of that context and it would be an unrelated activity. And again, you can do it, you just need to look at that substantiality piece. Yeah?
What if you rent out some of you have a large building, you rent out some of a space for office space, for events?
Mm-hmm.
So you're doing events, you might provide some catering or something. So.
If you do things like catering, that would be considered services. If you're just leasing the space and then they bring in their own caterer, then it's rents. And the other thing we look at on when you get into that level of detail is also whether you have debt on the building. If you have debt, that makes it taxable again. Again, you can do it. It's important to know whether that income is going to be taxed, because the corporate tax rates, state and federal, end up being about 40%, so pretty significant impact on your financial projections. But it's not a question of whether you can do it or not. You might not want to when you take off that hit, but different question. There's an exception for sponsorships, which is, we're a sponsor of this conference. We've got our name and logo on a whole bunch of different things. If you're just acknowledging a sponsorship, that doesn't cause it to be selling a good or service. If in connection with the sponsorship, people are getting a lot of return benefits, some of that is considered selling, advertising, and there's a bunch of rules in there. But sponsorships in general, your fundraising dinner where you sell tables and people get to put their name on the brochure and so forth are generally accepted. If the work is conducted substantially by volunteers, that's another exception. So my plant sale exception, a lot of schools here in the Twin Cities run plant sales in the spring. It's a fundraiser for the school, and it's just all parent volunteers, even though they're selling plants and maybe doing it in a way that's seasonally competitive with garden centers. The fact that it's all volunteers just takes it out of that taxable income. And then there's a special exception for thrift shops. If you're reselling donated goods, there's an exception for that. So, with that, I am going to hand it over to Jennifer.
Great. Okay. Good morning. Nice to see everyone. So now I get to do what I consider the fun part. Sorry, Sarah. So after we get the telephone call that says, you know, I want a B corporation, and we've annoyed whoever called us by asking them all the questions to get us to for us to be able to begin to interpret whether the activity is substantially related or not. You can see all the information that we need to gather and all of the questions that we're asking about exactly why, what did your 1023 say that you provided to the IRS in 1972? And how does this activity relate to that, what you told the IRS, and have you ever updated that information? So as we're looking at what substantially related means, you can see it's the first question, and then it drives the rest of our decision making here. But I'm gonna start with if the answer to that question is no. So I'm gonna work down the right side of this flow chart and then come back to if you have an activity that is substantially related to your mission, some of the reasons why you still might want to operate it as a separate organization. So if we've decided that the social enterprise that you're looking at is unrelated to your tax exempt status, then we ask a size question. And I am personally not a huge fan of creating lots of different corporations just to create lots of different corporations. Each legal entity you create creates a level of complexity. It can be tax returns that are required. To get liability protection, you have to really make sure you're separating out those operations at some level. And so particularly with a new startup venture, we ask this question of how big do we think this is going to be? And we know that it takes 3 to 5 years for a small business to begin to break even, which is always an astonishing number of years when I talk to kind of same as any small business, right, in the United States, and you look at how long is it going to take for it to generate profitability. And so you say, okay, well, during that period of time, we think this is a fabulous idea, but maybe it's going to fail. And then if we've gone through the work of setting up a corporation, maybe that was too much work to go through. So we ask the question of how big is it going to be? And is there, the rule of thumb around how much unrelated business income can you have? You look at it both from revenue and activities, 10 to 15% of your total activities. So if you have an activity that's unrelated but super profitable, you can decide that it's not so much of your activities that it harms your exempt status, or if it's something that takes an enormous amount of time but just doesn't generate much revenue, that can actually harm your exempt status too. So it's not just money, it's money and activities itself. And so if the other rationale for thinking about whether we're going to keep incorporate it or not is kind of the end game of the enterprise. Do we want separate additional investors in it? Ultimately, keeping it inside, there's a lot of benefits to it, but it might be that also that even from the get-go we want to create a separate corporation. And so if we decide to do that, we're on the taxable side of the world, so then we're in what we call a C Corp, and C just references the part of the tax code that you're subject to as a business corporation. So this is a type of a business corporation. So you'd incorporate either as a business corporation or these days as perhaps a benefit corporation or a regular business corporation that maybe gets a B Lab certification if we're interested in doing it that way. So this is taking your social enterprise and deciding we're going to put it in that taxable subsidiary. So we have decided it's an unrelated activity. And an example that Sarah actually worked on here locally is our Animal Humane Society created they have animal boarding kennel at the airport here in the Twin Cities. It's very clear from IRS rulings that that type of hourly or day boarding is an unrelated activity, so they put that in a taxable subsidiary.
It's actually now boarding, which is the tour
Yes.
this afternoon.
Yeah, it is. Oh, perfect. I had no idea. Yeah, and it's cool because they like drive you to the airport and you can leave your car there, so that's pretty slick. But so that clearly takes an activity that they know how to do, right? What does the Animal Humane Society know how to do? They know how to take care of animals. And so as they were thinking about their social enterprise, I always love them as an example because what they didn't come and say is we want to make dog food. Because you'd think, well, maybe they have some expertise there, but you don't know how to do a manufacturing plant. So as you're looking at your skill sets as an organization, they took what they really know how to do well and were able to put that into a taxable enterprise. Some of the other elements of creating a taxable subsidiary or moving your social enterprise in that entity, you get a legal protection separation from legal claims. And so that becomes important when you have the parent organization as a tax exempt is perhaps sitting in a perfect world on a super large endowment. And if that's our problem, we like to put operating things that create liability in a separate legal entity. So if there ever is a lawsuit, there's that slip and fall, there's something that's not insured, that we're not putting the charitable assets at risk for that. This also, as we're looking at wanting to grow that social enterprise, if we've kept it inside the organization, we're constantly monitoring how much UBTI do we have. If we put it outside, then we just go all out with regard to how much income we have. And that is always not a bad problem to have if you're able to produce a lot of profits. The parent organization gets their money back, typically in the form of dividends. They are, in this example, kind of the sole shareholder is the parent-subsidiary relationship here. Those dividends are not taxable to the parent organization. And we also can set up pretty frequently that the parent organization is going to make an initial investment. They're going to capitalize that taxable nonprofit. And in looking at that investment, you really look at your regular prudent fiduciary duties as you're making an investment. And so a lot of times that level of capital is not sufficient for that subsidiary to be operated. And so there are times when we then create loans coming from the parent down to the subsidiary. That can create UBTI back to the parent for the interest that they get paid. So sometimes perhaps instead we have the parent guarantee a commercial loan for the subsidiary, just looking at those different financing vehicles. Again, to get that liability protection, we have to do what we call respect corporate formalities. That means we need to keep separate books and records. We probably have a separate governing board. There could be overlapping. We probably have some commonality among the officers. Your executive director of the parent might serve as the CEO of the sub. We need to make sure as we're loaning employees back and forth that we're paying, if they're sitting at the charity, that this social enterprise is paying fair market value for those services. So you can tell the list gets really long as we talk about all the items and issues that we talk through it. But I think one of the most attractive pieces of doing this is that your ability just to attract outside investors. This picture shows a wholly, 100% shares are owned by the parent. But clearly, if you're going down this path, one of the items you're going to be looking at is getting outside investors into that organization. And the corporate form for that social enterprise, either, as I said, a business corporation or benefit corporation if you choose to incorporate under one of the benefit corporation statutes across the United States. And you do not have to have a benefit corporation in your state. You can incorporate under Vermont. Delaware is now putting a benefit corporation act. We always like to use Delaware, and the reason for that. generally is because they have the most robust history of case law around corporate issues. And so a lot of people automatically go to Delaware, particularly if they're going to operate in different places in the United States. So you can always incorporate in another state and operate in your local state as well. So that's another option.
Will you explain in detail what a benefit corp is?
Yeah, so
Why would it be that versus just the business?
yeah, so a item of robust discussion, particularly in Minnesota, where we have a task force looking at adopting a benefit corporation act, and I happen to be on that task force. So a benefit corporation is really simply a type of business or taxable corporation. It does not have a tax status like being a nonprofit corporation does. It is a taxable enterprise just like any other business corporation, except it allows, in the text of the statute itself, it permits the corporation to articulate identified social purposes that can trump the mission of that taxable entity to make money for its shareholders. So the general corporate theory of businesses is that the purpose of that corporation is to make money for its owners, its shareholders. And so there is concern, there can be concern in the, as you talk to lawyers, about when you want to put that double or triple bottom line, if you want to put the environment over, maximizing your return for profits, does that create legal risk for the board of directors, for the executives of that social enterprise? And whether that is a real risk or a risk that lawyers think about and worry about is yet to be seen. I don't know of any cases yet that have actually alleged a breach of fiduciary duty in that circumstance. So that's kind of the underpinnings of why we have benefit corporation statutes. I also see a lot of value and conversations with clients about the, for lack of a better word, marketing or messaging of saying you're a benefit corporation, which I personally think is the more valuable piece of it. I think it certainly communicates something when you say I'm operating this franchise, but it's a benefit corporation. It's clearly a for-profit activity. When you look, it's a McDonald's franchise, but you're saying we're gonna, it's our social enterprise, and we're gonna operate the most green McDonald's you can. I don't know if you can possibly operate a McDonald's in a green environment, but let's just pretend. So that would really communicate, right, to your investors and to the public, the types of folks you're trying to attract. So from my perspective, that's kind of the reason to do it, and some of the discussions that are happening. But it's funny because it's just been a hot
Do you
topic.
save any money doing that?
No, has no tax impact at all.
No tax impact.
And that's part of the concern, honestly, is that it's a very hard, it's a complicated concept and it could be misconstrued. Yep.
Somebody yesterday said there was a difference between a benefit and a B Corp.
Yep, yeah.
Will you talk about that, or is that germane here?
Oh, sure, I can talk about it. So a benefit corporation is actually a different type, you would incorporate under a benefit corporation statute. So if you're a nonprofit corporation, you have incorporated under a nonprofit corporation statute in whatever state you're incorporated in. Or if you're a regular taxable or business corporation, there's a Business Corporation Act. And so there's a Benefit Corporation Act that sets out all the rules and regulations surrounding what it means, the restrictions, and what you have to do to be able to say you're a benefit corporation. And so some of that would be an annual report to the public. For example, if you've said, these are our 3 social benefits we're going to provide, then there's going to be a requirement usually to produce a report that it illustrates how you're doing that. A B corporation is simply a certification, and it can apply to any type of corporate form. So you can be a regular business corporation incorporated under the Minnesota Business Corporation Act, but you go to B Labs and fill out their long survey, and if you get their certified stamp of approval, you can say you're a B Corp. So that's the difference between B Corp and benefit corporation. And so, pardon me?
What is the advantage or disadvantage of being?
The advantage of being a B Corp is that if you're an existing entity right now and you're a business corporation, you don't have to reincorporate and do all that stuff to call yourself a benefit corporation, but you can get that stamp that you can then use from a again, it's a communication. I think it's also a means to hold the organization accountable internally, that this articulate really clearly to your staff and your founders and everyone else that this is what we're doing, and to keep our certification, we're going to have to continue to operate in this way that puts these social purposes perhaps above, again, the operating for-profit.
I thought I read that the benefit corporations also can receive like PRIs.
Not, from a legal standpoint, there's no difference from a flexibility standpoint from PRIs. Any type of business corporation could technically receive a PRI if the rules associated with what it takes to be a PRI are followed by the private foundation. And so a benefit corporation, from a technical standpoint, has no different status from a compliance with those rules right now. And the IRS has actually explicitly rejected looking at whether they would make flexibility. And since, as we know, the exempt organization branch is kind of busy testifying in front of Congress these days, I don't know that it's something they're going to take up soon. But it is an item that, and the same thing with an L3C. Again, no technical legal, it's not easier from a legal standpoint to accept PRIs if you're an L3C either. Whether there's a perception issue, whether private foundations, might be slightly more comfortable. But from a technical standpoint, a private foundation that requires a private letter ruling to do any PRI is probably going to still want to do the same thing if you do an L3C or a benefit corporation. Program-related investment. I was going to say publicly related, which is completely wrong. Program-related investment. And that's a type of investment. A private foundation can make an investment that probably has less returns from a fiduciary duty standpoint than a regular for-profit investment. But again, they're doing it with a social mission to it. It's maybe a low-income loan, and there are a lot of rules around how charities can use their assets, and generally you would not be able to benefit a for-profit company by using charitable assets to make a low-income loan. And so there's a whole host of rules a private foundation has to satisfy to be able to do a PRI.
So if I'm hearing you right, you're saying if you already incorporated a 501c3 and you decide your mission is not related, so I think that's true, then you can incorporate that either under a benefit, you can call it a benefit corp from the beginning.
Yep.
And if you already have one, you just want to get certification and to become a B Corp, which is taking
Yep, you do.
tests.
You do B Corp.
They're the same thing.
Yep.
Jennifer, I want to make sure I heard you correctly. Is there an IRS determination that a benefits corp, the unrelated taxable income is viewed differently if you're a benefits corp versus a C corp?
Benefits Corp is not going to be subject to unrelated business taxable income because it's subject to general corporate income tax. So it's subject to the same taxation as a regular business corporation. And so the UBTI issue is from their standpoint, they're looking at and filing a Form 1120, which is the tax return of regular business corporation files.
But there's no suggestion that a benefits corp can have a higher proportion of unrelated business income.
So a benefit corporation can do, we're not worried at that. As soon as you're a taxable entity, like a business corporation or a benefit corporation, you can do anything you want to in that corporation. Just make money. Yeah, you're not tax exempt, you're not worried about protecting that. So you can do all sorts of different, you can run a franchise and a dog walking service, and, whatever you want to do all in the same entity if you wanted to.
Are there any discussions at any point in the United States about a hybrid, like there is in the UK, for example, under taxation for a benefit corp or whatever it's decided to be called?
I think the hybrid, which isn't much of a hybrid, is the benefit corp or the L3C. I mean, there isn't, and it isn't a hybrid from a tax standpoint. It's either you're tax exempt or you're taxable, but you can do the social, you can put social mission over your obligation to maximize profits. If anything, maybe a hybrid is actually a tax exempt entity that is operating a for-profit business kind of inside for a while and staying but within that 10 or 15% of its activities. It would both be tax exempt for some of its activities and taxable for some, but that's kind of where we are right now, is the benefit corporation as kind of, or the L3C as a kind of hybrid.
So there's no movement or lobbying or anything?
Not that
I think there are people who are interested in
Yeah.
talking to Congress about it, but there's not a lot of traction.
That's an understatement, I would say.
Yeah, I think that's right. I mean, I think it's evolving, and normally the corporate structures really are, obviously they're not the leaders of movement in this way. And so, 10 years ago we didn't have any hybrid type entities at all. We just had for-profits or nonprofits. And so from then, we've had, you know, this other smattering of options that people are beginning to get more comfortable with. Like there and then. Yeah, yeah.
How much of your income, your pre-tax income, can B Corp or actually any business corporation donate?
I think the charitable contribution limit is 10%, and I don't know if that's like an adjusted gross income, probably.
Yeah, so you can donate as much as you want, as long as it's
But it's-
consistent with your
yeah.
fiduciary duties and all that.
But it's
But
only
the deductible limit is 10% of adjusted gross income.
Right, so you pay tax on the rest. In Canada, it's 75%.
Huh.
So I guess we avoid a lot of these problems.
Yeah, I mean, and there is a lot of support that for-profit taxable businesses do to nonprofits, and they don't call them charitable deductions, they call it marketing. And so,
And there's no limit.
and there's no limit on how much you can.
Business expense.
It's just a
Yeah.
business expense. They decide to do a sponsorship. I don't know that, I've been doing this for 20 years, I've ever had a for-profit business worry about whether it's a charitable deduction or not. You know, United Healthcare, which is, you know, the biggest health insurance company, and it's here in Minnesota, you know, it does a $20 million contribution to our local children's hospital. I'm sure they're calling it a marketing
So
expense.
that's how you get away with that. You call it a sponsorship to your own charity.
Yeah, and to the hospital, I mean, we craft those things very carefully, so to the hospital, it's not advertising, but I think in the nomenclature of that business, they're just saying, you know, my name and my brand is up there, and it's marketing from their perspective. So we you know, dance that dance a little bit, but not taxable income to the charity. So there's a whole host of just kind of other legal considerations as you're thinking about having a taxable subsidiary. We've talked about the state corporate law and the choice of form. If you have your taxable subsidiary officing in the offices that your tax exempt organization is sitting in, and there's tax exempt bond financing, there can be implications for the fact that you have a taxable enterprise there. You're going to have to rent that property, or that space, the office, to the taxable subsidiary, and so there can be some tax exempt bond issues, property tax exemption again, if you're sitting in real estate that has property tax exemption and you're operating your taxable business out of it. Usually the assessors will come in and assess property tax on the portion of that building that is now being operated as a taxable enterprise. There can be some employee benefit issues, et cetera, and intermediate sanctions are the rules that we look at generally around fair market value compensation for your executives or for insiders. If we have controlled subsidiaries, we are combining the compensation of the executives if they serve as executives of both organizations as we're doing some of our disclosures. So there's just a kind of a little layer of complexity as you go into operating it as a separate enterprise. And so now we're back to our chart, and we have looked at whether, from a size standpoint, we've decided, yep, this is going to go gangbusters, so we've decided to incorporate. There are sometimes other reasons. The other option that we have is to keep the activity inside the organization. We've decided that it's unrelated, but it's not going to be so big that it's going to harm our tax exempt status, or we're doing this kind of on a transition basis until we see. And some of the issues around keeping it inside are, if we've decided it's unrelated, really important to account for that activity separately, so that as you're paying and calculating your unrelated business income tax, as you're calculating, you are you are reducing the amount of taxable income as much as you can, so the amount of income that you're paying tax on is as small as possible. And so you really want to make sure that you are allocating your expenses appropriately around that unrelated activity. This is obviously the simplest option to start with from an enterprise, because we're not worrying and not incorporating the separate entity. We simply are just operating it within the four corners of the organization. Sometimes you can consider it a project, you consider it a division, and that can help that separate finance, that separate accounting. And then the other piece that you might do too is it can help you as you're doing that divisional accounting decide when it's appropriate to spin it out into a subsidiary, if it is ever appropriate or required for you to do it that way. And so one of the pieces there, if it's kept inside the organization, does it feel, if it's an unrelated activity, You know, how much of your time is now spent on this taxable enterprise? That's a reference to mission drift. That can be a concern for boards. It's less of a legal concern. And then just looking at the growth of it again and saying, when has it gotten too big and we need to spin it out? So that's another piece of that activity as well. And we sometimes see this, even if it's a related activity, that people really want to think about it as a separate business. Like it might be an activity that is, we've decided from a technical standpoint, yeah, it's related enough that we're comfortable, but from a business standpoint, you want to really hold it out. You might want to market it separately. You might want to have a brand on it, and you can do all of that inside that corporate entity. You can have its own advisory board, and you can, you know, for all sense and purposes, the public can think it's a separate thing if you do it, if that's important to you, that it feels different. And that can be really important, that you have staff that you articulate that this is mission, but it's also about making money, which can feel different in kind to folks. So now we're back on the questions we're looking at is whether there's any other reasons, if we've decided, there are any other reasons to keep the organization as a separate activity, either on a related or an unrelated side of it. And so the reasons that we think about here, so maybe we have a related activity. And I'll use an example. We work with the University of Minnesota Foundation. They luckily have $2 billion in their endowment fund. So as a lawyer, I think of them as a big pot of money, which is exactly what they are. So I don't like them to have operating activities inside the big pot of money because there's lots of lawyers around who are not like us, they're unscrupulous, and they like to sue people. And they were given a very generous gift of student housing, a $50 million gift a few years ago. And so we have that as a separate but related subsidiary for them, so that it can be separately insured, it can be separately managed as a separate type of business. Again, liability considerations, insurance considerations have that. They operate as a separate enterprise from that standpoint. It could also be from a licensing standpoint. We have a client that does Hammer Travel that has they work with individuals with developmental disabilities, and they have residential homes, and those they have all sorts of licensing issues. They have a travel service. It's a related activity, but to keep that licensing separate and keep the liability separate, they put out a subsidiary, a related subsidiary, but it's a LLC in that context. So this is, so that from a related standpoint, and a limited liability company is a type of legal entity that is it's like the best of both worlds type of entity. It has flow-through taxation, meaning it does not itself pay any income tax. The owners of an limited liability company are taxed on the revenue or the income that's distributed to them. But it creates a liability shield from a state law for state law purposes. And so it is the most commonly type of formed legal entity these days. And I think in Minnesota, for example, it's well over 80% of new legal structures formed in the state are limited liability companies because they just are so flexible. And so a limited liability company, again, we're looking at the corporate statute. Most states have a limited liability company statute. And then there's an L3C. That's again a different corporate statute that you can incorporate under, similar to a B corporation, that again allows the governance and allows the owners to put that social mission above earning money from a fiduciary duty standpoint. Minnesota is odd and interesting because in our LLC statute we have a concept of a nonprofit LLC. And that allows a limited liability company formed in Minnesota to have a purpose that is not related to making money. It can have a nonprofit purpose. It predated the L3C movement. And in Minnesota previously we had our LLCs had to have a business purpose, and there was confusion about whether you could create them for nonprofit purposes. And we do create LLCs when our organizations are engaged in related activities, primarily for liability protection. Very common for residential facilities to each have their own LLC around them. Or a nursing home, for example, that has a nursing home, assisted living, and a memory care facility. They might all be separately incorporated as LLCs. They file 1/990, it all rolls up to the parent, but again, to get that liability protection that the LLC form can provide. Those activities of the LLC are passed through and considered activities of the parent. And so, again, we have to be very careful that they're either related activities or they're unrelated but small enough. You also can have outside investors in an LLC. And so it's not uncommon for owners of companies, if they want to make a charitable deduction, to give part of an LLC interest in a hotel to a charity as a charitable deduction. And then for a period of time, that charity owns part of a hotel. And if it's a small enough part of the charity, that's fine, but they're going to pay tax on the income that's coming from that. So you can certainly use it as a vehicle to have outside investors in that activity as well. As I mentioned, the L3C is a low-profit limited liability company. Again, no significant purpose of that L3C can be the production of income. The exempt organization has membership interests kind of on the same terms as any other owner of it. And you certainly can, in an L3C or a regular LLC, because it's such a flexible vehicle, you can bake into the corporate documents any type of restrictions on the owners and the members and the mission of the money, that kind of stuff, as you really want to. And so I think there are probably, I think there's like 12 states right now that have L3Cs in place.
But this is one like the benefit corp, or if your state doesn't have it, you can incorporate in a state that does and then just be a foreign entity in your own state. So it's available to anyone in any
Yeah,
state.
exactly. It's the same idea. Yeah.
So in Minnesota, when we do a nonprofit LLC versus an L3C?
One, we don't have an L3C statute in Minnesota. And, we put together the nonprofit LLC for a very specific purpose, and I happen to be one of the authors of that. And it was because the IRS had picked Minnesota as a state in which it said, can a nonprofit have an LLC as a related entity? And because our statute said you had to have a business purpose, the IRS took the position that you couldn't. And so we simply wanted to take out the word business purpose and say any legal purpose. And to accomplish that, we had to work with our Attorney General and came up with this nonprofit LLC concept. So it isn't that we were on the forefront. All honesty
You could just
aside,
tell that in
just
a whole
among us.
different way.
So it's, it's a little bit of a different, it doesn't have the same concept of no significant purpose as the production of income. It does not have that limitation at all. And so that really, from an L3C standpoint, makes an L3C distinguished. I also think that, again, like a benefit corporation, like a B Corp certification, there's a communication aspect to saying you're an L3C, right? There's a kind of a branding or marketing that when you say you're an L3C, people in this community know what you mean. So that to me is why people use that.
Can foundations grant money to a non-501c3 and still be able to write that off as a charitable contribution?
Only if it's, and was your question whether private foundation?
Yeah, I'm
can?
just saying if you're non-related
Yep.
businesses that, and you call yourself a nonprofit LL3C or B Corp, where you truly are still a corporation, can you write a grant to a foundation and then they still be able to grant you money, but you're not a 501c3?
Yeah, yes, if they do it right. And the doing it right part is kind of the technical side of it all. It has to be restricted for really what's considered an exempt purpose or activity within that for-profit enterprise. They have to do something called having expenditure responsibility over the money. So, yes, but it's complicated. Or you can do a program-related investment. Again, yes, but it's
And
somewhat
that's
complicated.
where that program related is.
The difference with an investment is they intend to get the money back.
Right.
Okay.
Whereas with a
Grant,
grant,
they don't ever.
yeah.
They don't, which means the standards for grants are higher, right? Because they're not
Right.
going to get it back, and so the connection to their charitable purposes has to be that much stronger.
Thank you.
Yeah, and their oversight, the ongoing oversight of it as well.
So this is a really basic question,
That's
but
fine.
what's the difference between an S Corp and an LLC then?
So an S Corp is a regular business corporation that has made an election with the Internal Revenue Service here to not have corporate level of taxation. It's again taxed kind of like as a partnership it's taxed at the owner level. And the types of, it can have, I think it's less than 50 owners. It can't have other corporations be owners of an S corp. It's really used as like a sole proprietorship. Very commonly, you form as an S corporation. And a limited liability company doesn't start as a corporation. It looks like a partnership in some respects. And they don't have that same tax election, and nor does it have limitations on who can own it. I'm sorry. No, I was just gonna say, and in an S corporation, although a tax exempt organization can actually be an owner of an S corporation, all of the revenue it gets is under the tax code UBTI. So we just never use them from an S, when we're talking about social enterprise, just because a tax exempt owner doesn't make any sense, just from a tax standpoint. That's okay. Okay. Is that? So we are at the end. We've answered all the questions, right? We started with a simple question, the simple telephone call that we get. I want to be a B corporation. We have now had a long telephone conversation, and usually our clients go back and do a lot of thinking about what their business goals are. You know, I think if there's any takeaway from this is legal structure should not drive what you're doing. You know, it is really cool to talk about B Corps and L3Cs and benefit corporations and all that stuff, and that's great. And I think there's a lot of, like I said, a lot of communication that can happen when you are incorporating a social enterprise in that way. But really needing to look at the beginning, this analysis. Is this related? Is it unrelated? What's our end game with this enterprise? You know, do we want to sell it to eBay? Or whoever the big for-profit company is, and we want to make a ton of money, okay, then we might want to have it as a separately incorporated thing from the get-go, because then I can have outside investors. I'm not limited by how much activity I can have in it. I can go all out in making profit and not be worried about this 10 or 15%. And if that's your end game, that's really important to know on the front end. And what type of investors are you looking for? Are you looking, is the charity going to be the sole investor? Do you want individuals to be able to invest? Do you want your employees to be able to invest? Do you want to go out to the market and get venture capital? There's all sorts of complexities around that kind of for-profit side of the decision-making that really should and can be part of the conversation as you're looking at what is your social enterprise looking at. Is your end game not to sell it, but to have it be an integral part and provide ongoing financing and financial support for your charity? Then maybe it's less important that it's a vehicle that's familiar to the venture capital world. I would say right now, when I talk to Chris Carlisle, who's one of our partners that work, we have a group of for-profit lawyers. They work in a group called Entrepreneurial Services Group, so they work with startups every day. I can't imagine that Chris, if he's thinking he's going out to market on a startup company, is going to probably put it in an L3C. It's not a vehicle that people understand yet when you're talking about funders that are outside of this world. And 5 years ago, we almost said that with LLCs, and now people are pretty comfortable with LLCs. But so there's a lot of thinking that goes into the ultimate decision about what structure that you end up picking. So I think with that, there we are, okay. So we have 10 or 15 minutes left. If anyone has any additional questions, we'd be happy to.
And then we'll be outside
And we'll
too.
be outside.
Can you email us a copy of that?
Sure. If you want to give us your card, that'd be great.
Yeah.
There's some in the back.
Oh, there is? Oh, yeah, there's some, and then we also have a handout, there's a second handout too that be sure to take that is a
It's
one-page summary.
It's one page of this, and then the flip side is the different types of legal entities with some kind of pros and cons and descriptions around them too, so.
So I have a financing question. Obviously, if you're looking for outside investors, there's some benefit to this. What about the bank? I mean, most of what you talked about is liability and, sort of managing that. Does the bank, if you're looking for traditional debt financing, like this LLC or something that they understand better than a not-for-profit structure?
The L3C and Benefit Corp would probably be less familiar, and so you would have to have more discussion about likely have more discussion about what those are. If it's in a separate entity and it's a startup, they're just looking at the balance sheet and the pro formas.
Right.
And then they're gonna immediately want the parent to issue guarantees because the balance sheet and the pro formas are all gonna be, you know,
Zeros.
hypothetical.
Well, we have an existing,
So-
you know, it's a several million-dollar business inside a bigger
Mhm.
not-for-profit, and we're just trying to figure out, are there some reasons to move that out?
So,
Specifically to make the financing part cleaner to explain.
and it, well, there's the cleaner to explain for, in your example, and then the other is, if you do financing and you can have it be just at the subsidiary level, it's just a liability of the subsidiary. And it shouldn't affect the borrowing capacity of the parent or the financial statements of the parent, and that can be a real advantage. So in, like Jennifer mentioned, the nursing home example, I do a lot of work in that field, and one of the reasons is liability protection, although, like, people falling down or getting hurt, they, you know, insured, right? And so that doesn't, I mean, you're kind of doubling your protections on that one. It's really about the financing, because then they each have their own financings, and the balance sheets of everybody, you know, are different and separate, and that can just leverage a lot more assets than if they were all together in one.
And even if the parent has to do a guarantee in that standpoint, normally a guarantee is just gonna be a percentage, maybe 20 or 30% of the total amount guaranteed is gonna hit its balance sheet from it, the parent's borrowing capacity. So that can be, and if the parent is gonna be guaranteeing the debt of a for-profit, I do make that, for-profit pay a guarantee fee, a commercially reasonable guarantee fee back up to that parent tax exempt organization too. But that can be a really nice way to leverage, you know, if you have a nonprofit, again, that has an endowment or something else, that can be one way to leverage that without really putting the dollars at risk on dollar one.
Were some other questions? Yeah.
Performance C Corp, we've talked to several people and they've really pushed against having employees on both organizations, on your 501c3 and on the C Corp. Is there exposure, risk, liability with doing that, or what's your recommendation?
So, you know, the challenge is if all your employees are sitting at your parent charity and they're providing services to the subsidiary, the C Corp, that C Corp has to pay, they have to reimburse the parent tax exempt for those activities. And if that C Corporation is engaged in an unrelated business, those payments back up to the parent themselves are unrelated business income. And so that doesn't really, you know, get everyone too excited. So a lot of times if you're gonna have dedicated employees, I do tend to put either those employees in the taxable subsidiary. I mean, different employment terms and compensation can be one of the drivers of actually creating, right, a subsidiary. You're not gonna be limited in the same way that you are at the parent charity. You can maybe do more incentive type compensation, maybe gives you an opportunity just to pay these people kind of differently than if they're sitting at the parent. So I actually see that separate ability to have separate employment as being an advantage in some respects. And if there's gonna be folks that are gonna be providing services both at the sub and at the parent, sometimes we move them wholly into the sub, and then the charity buys them from the for-profit sub, and that's fine. And they can even buy them at cost or below fair market value, because that for-profit can always benefit the parent charity.
It's the other way around.
It's the other way around that's a problem. And so if that sub has to pay fair market value if those employees are sitting at the parent level.
The short answer to your question is that there is no answer. It's, I mean, this is one of the more thorny and, you know, organizationally unique parts of setting up a separate subsidiary is how does it make the most sense to have those staff? Where does it make sense for them to live? What are the benefits considerations? Are there collective bargaining? I mean, there's just so many different things that there is no, oh, never do it that way, answer to that question.
Because you didn't, you can never, or my question, can you ever incentivize an employee who is under the arm of the nonprofit to the social enterprise itself? Is there
Well, you
any-
can use, I mean, you are allowed to have incentive compensation in a nonprofit. You have to
Okay.
do it right. It has to be the right kinds of incentives, that you're not incentivizing bad behavior, and there's some limits on how much you can pay. It still always has to be reasonable compensation. But it is possible to have incentive compensation and have it be tied in some respects to the performance.
That it's easier if
You have
those
more
same
flexibility.
people are gonna be into the profit part of it, but move them over.
Yeah.
And sometimes it's just the justification for why do you have a separate kind of compensation plan. And I've even done it in a related context. again, a large foundation decided that it needed, its endowment was getting so large, it has its own captive investment company that has its own staff, and to be able to, certainly could have done that inside, right, the nonprofit, it's only investing its own assets, but to be able to do incentive comp like they needed to for that chief investment officer, and also for that person's compensation to likely be hired. If they did well, which everyone wants them to do well, then the CEO, we put it in a nonprofit that's a separate, wholly controlled, but still a nonprofit, so.
There's a question in the back.
Yeah, could you just talk a little bit more about limits on incentives, payments for staff in a not-for-profit? So I run 12, 13 thrift shops, and so we have both for sales staff, bonuses and that sort of thing, and also as you kind of like move up, you start to get, between 10 and 15% of compensation becomes performance-related, sales-related.
Sure. So the thing you cannot do is have a compensation system that basically distributes the profits. Okay, so that's the one thing, like, you just really can't. So when you're looking at an incentive compensation, you want it to be, there needs to be a cap. And this is the higher up you go in the organization, the more critical this question becomes. You want it to be subject to a cap so there isn't some windfall unrelated to the person's contributions. And that cap needs to be reasonable compensation for what they're providing. But, reasonable is a big range, but, you gotta have some point at which, beyond that, it would just be a silly, an exciting windfall for the person, but beyond really a reflection of their contributions. The IRS prefers to see incentive compensations that are incentivizing people to behave in a way that furthers the mission of the organization. And so, the most discussion about this has been in the healthcare context. And they have said, if you have a CEO of a hospital whose incentive is based just on the balance sheet of the hospital, well, one really quick way to get there is to cut services. And that would, and especially the services that don't make money. And that would undermine the charitable nature of the hospital. And so that's not okay. But having a CEO who, needs to have a healthy balance sheet in order to also get their incentive comp that's also tied to furthering the charitable mission, serving needy people and providing quality health care and doing, all the triple bottom line things, and that the balance sheet health is one of the factors, that's just fine. I think then the job for the rest of us is to translate that paradigm that's been pretty clearly articulated into your thrift shop staff and what's the right metrics for them that's balancing all those different things. And it might very well be in that context that sales is an appropriate measure of the work that they're doing and contributing to the mission of the organization. But I think you want to have thought about it, and the IRS is like your math teacher, and you only get credit if you show your work. So
Write it down.
Write it down, right?
Yeah.
In the job description or in the description of the incentive compensation package, say why these metrics make sense. We're paying, a percent of sale, 30% of your salary is at risk tied to sales because furthering sales furthers our mission, or whatever the right thing is.
And yeah, two other things. Certainly, what we see a lot is using the financial performance of the enterprise as a trigger. So the bonuses are only available if we hit a margin of X. And so you're not paying out that margin, but this is the trigger, and now this incentive pool is available, and you pay it on what I call good factors. The other piece is really looking at compensation surveys to the extent you can find surveys that have comparable. And, although, I think most organizations go, we try to pay at the 50th percentile. There's a compensation survey that goes up to 100% for a reason, right? But again, it goes to that documentation. I have actually been representing a client in an audit where they paid their CEO at the 60th percentile with an agent saying that's unreasonable compensation. Prove to me why they should be at 60 and not at 50. And I'm like, really? This is crazy. These volunteer board members, they had gone through all of this process, and we had the process, right? And we had the justification in the board minutes. And so we beat them down. We just said, come on, these people are volunteers. They're doing the best they can. They're not paying at the 120th percentile. So again, I think kind of doing that, showing your work and making sure you've done that thinking is as important as anything. But there are times, and Sarah and I both work a lot in the healthcare field, that you look at a salary survey and it doesn't have the type of subspecialty physician on it. There just are only how many pediatric cardiovascular surgeons. So they might get paid 120% of the, most equivalent type of surgeon, and we just document the heck out of it and move on. So it's kind of what you have to
A
do.
real quick follow-up on that. When you're referring to compensation parameters, are you referring to for-profit compensations or not-for-profit compensations?
Yes.
It really depends on who
Next
you,
question.
who you compete with for the talent. And if it's a job where people do a similar job in a for-profit context as they do in yours, so it's your chief financial officer, then absolutely you can include for-profit comparables in your data. If you're talking about a social worker or some other job category where really the market are other nonprofits, then it would be inappropriate to include some for-profit that doesn't really compare in terms of the market for that talent.
But the IRS has clearly said that taxable comparables, if they're comparable, are okay.
Yeah. We have been instructed we have to vacate our room on time, but we're going to be, we have a booth outside, so we'll be outside if you have more questions. Thank you. Vacate.
Just wanted to say hi. I see you guys everywhere. My name's Amy Wagner. I work at MAP for Nonprofits.
Oh, sure.
Yeah,
Nice
hi.
to
Nice
see
to
you.
see you.
Nice to see
you.
you.
Yeah, I heard you guys must have done something similar at the
Oh, yeah. We've done-
United Way.
Yes,
at the
we did.
CAE.
Essentials, yes, I did that
Well,
on
at the
Sunday.
CAE, though. Did you go to the CAE retreat?
Yes.
Yes,
Yeah.
okay, yes.
Yeah.
Heard good things.
Well, good.
Yeah, this is like the third time I've heard this, but it never sinks in, so this helps.
Oh,
If
I
you
worry
guys
about
wanna,
that too.
Link some of the stuff on your website or anything, we would be happy to do that. And the other thing is,
Hi, I'm Judy.
Nice to see you.
That's fine.
Some other questions that I get routinely that.
Oh, I didn't even do that.